Welcome back to another episode of the Mia Money podcast. As we talked about last time, we're kind of going to do a little estate planning mini series here. So today we're here to talk about wills and trusts. Those are some big words. Sometimes I always get an interesting reaction when I bring up trusts to my clients, especially working with the younger folks. They're like, well, I don't have millions of dollars. I don't need that. So hopefully we can shed some light today on why that you don't need to necessarily be a millionaire or multimillionaire to make use of them. But let's dive in, Elliott. Where do you want to start today?
Yeah, well, I'm excited for this one just first because actually this question came up in a newsletter this morning. Someone had emailed me and said, hey, my attorney's suggesting a trust. I have a will currently. When does that make sense? And I think we'll talk about some of that today. But I think just to refresh, maybe we do the basics of a will and a trust and then go into maybe the differences and when they apply, if that sounds okay.
Yeah, let's do it. Well, because they are very different, right?
Yes.
One does not replace the other.
Yeah. They can work in tandem as well. And I think that's important to keep in mind. So just broad perspective here, a will is going to say what happens when you die. So that could be to your stuff. If you have kids, who's going to take over as guardian, and you can name successors if the first person can't or is unable or unwilling. So really, a will comes into play when you're dead and what happens with your assets and other things. A trust can also sort of do the same thing, except for in reality, what you're trying to do is you're trying to transfer everything to the trust, so nothing really flows through the will. And maybe, Matt, do you want to talk about this concept of probate as we talk about why we do trust versus will?
Yeah, I think we should go there, but I think we should, let's kind of paint like the whole picture first, right? I think like rather than flipping back and forth between the two, like let's just go heavy on the will. Let's explain like what happens there. And then we can explain how a trust can help backfill some of the gaps that maybe a will can create. So I'm really curious, Elliott, before we get too much into the nitty gritty, like when you're talking to your clients about their will, like what are some of the questions that you bring to them to help them understand maybe what that will should look like?
Yeah, I think just big things of who's going to be responsible for this. And I had an attorney in the past who always joked, pick your least favorite kid for the executor. And that's funny because it's a very thankless role. You obviously want someone responsible in that role, but they're essentially going to do all the paperwork and all the administrative stuff, maybe talk to attorneys. It's a long process and often takes over a year. Maybe we're talking 6 to 18 months, depending on the complexity and what's happening in your state. So it's not a role to be taken lightly. So who do you want to be responsible for that? And then more importantly, who are the backups? So I think a lot of people, when I'm working with clients, they might name a sibling. That sibling may or may not die before them. In which case, who's taking over in that role? And naming a lot of different people, I think that's helpful. Sometimes people only name 2 folks. Well, what happens if one passes away and then you're driving, I don't know, with your son or daughter and you've named them the successor? That can be a real issue. So thinking through those steps, it's kind of a morbid game, but I play off, kill this person, what happens, right? What happens with either executor or what happens with your stuff? So often, like, who do you want to go to your stuff and what is the line for that? And we can get into more complicated things like per stirpes or per capita distributions. Like, do you want some person's share to go to the next generation? Or if they die, should that go to another person? Does it go to a spouse that they're married to? There's a lot of complexity in family, different dynamics and relationships that if someone passes away, let's play that game of this person passes, where do those assets flow based on anybody else who's still alive? So I think the biggest value is having those conversations around what happens and thinking that through. What about for you?
No, I love that. I think what I would add to that is I really just leave that as an open-ended question, like rather than, framing it to, who in your family do you trust, like who around you is organized and is trustworthy, right? And I almost always recommend, again, not that it's a legal recommendation, but more of a suggestion that, you do look outside the family, at least for one contingent, because like you made the great point, right? Like what if it's a family trip and everyone in those key roles is on the bus, so to speak, when the bus goes off the cliff, right? Like that's a real problem. And it's a lot like investments, right? Like, again, it's a bit morbid to think about, but you have to diversify away from the people that you simply spend the most time with, because the odds of, all of you dying at once are much higher if it is, right? So I'd like to just start with that question, like who do you know and trust and is organized, right? It doesn't have to be a family member, and I think a lot of times people don't even know that. Like they think that it has to be a family member or it should be. So I just like to open that up. And kind of to your point, I'd never heard that joke to give executor to your least favorite child, but I always like to ask, are there any people in your family who are a problem? Like
Yeah.
who could be a sticking point in some of these things, or maybe get a little bit greedy if things aren't properly administered and sent to the proper place. And so that's kind of that proverbial thing that you hear, right? Oh, I got written out of my father's will or whatever. Like, are there people you want written out of the will? Because you should definitely take note of that.
Yeah.
Yeah.
I like that. Yeah. You got to understand family dynamics and what may or may not happen, and then talk to the attorney about what's the best way to actually structure that. If you do want to write someone out of your will, as an example, what's the proper way to do that may cause the least amount of harm to everybody else in the situation?
Yeah. Yeah. And then on that point too, just the amount of things that you can list in your will, like, I think again, this is a really good opportunity to either have discussions with your children, like what do they expect, perhaps, maybe that's nothing, but I bet there are some things that maybe are smaller that they may not even be thinking about. Like, I'll never forget when I was working, in life insurance, there was this beneficiary claim that I had to do, and these three siblings were just like at each other's throat the whole meeting. Like, I had never met these people. Like, I was just assigned the death claim, and like it was all because of something of their mother's, that one they all wanted it, but only one of them got it, and it was just like this nightmarish situation of family infighting. So I think too, like, just thinking about those sentimental pieces, like having that conversation with your children or with your parents, like if there is something sentimental that you specifically want to go to a specific person, this is the place to do it, right? So those are usually the two places I like to start. And then, of course, working with younger families, like there's usually children involved, and understanding what that looks like and who's going to take care of them. Are they able to take care of your children well, or are they even willing? I think most people are willing, but like willing and able is usually a different question. And
Yeah.
having that discussion is really important too.
Yeah. I would also add that, like, once a document gets produced or you see a draft, make sure you understand it. I met someone one time where we went through their estate planning documents, and it didn't mirror anything that they thought it said. And I don't know where that got lost in translation, but these documents are very traditionally very legalese, and so just making sure that you go through that carefully with an attorney to make sure you actually understand what it's saying is really important. And again, going through those different scenarios.
Yeah. And I think too, this is why you should, just like if you're hiring, one of us as your financial planner, right? You should interview multiple people. And I just had a conversation with the client, I think it was last week or the week before, but they're like, is it common for you to like tell an attorney something and then they just start like word vomiting on you with like all these things? And by the end of it, I was confused and frustrated. And I'm like, yeah, that sounds about right. Like, maybe we need to find you a different attorney though. So again, you get what you pay for. And if it doesn't feel right, like, again, seek a different attorney, because you're spot on, Elliot. Like, I couldn't tell you the times I've read through the documents, and if you read it, like, legalese isn't necessarily easy to read, but if it sounds like it's doing, even if it's the same words but it sounds different, like, it probably is
Yeah.
different. And that's a really good thing to bring back after those drafts and say, hey, like, what does this mean?
Yeah. I'm trying to think, is there anything else for wills that you would cover?
um I mean, I guess we haven't talked much about like charitable inclinations, right? Those could go here. It could also
Okay.
go in the trust. um I don't know, maybe maybe some discussions around like burial arrangements and final expenses. Like, I don't know, have you
Yeah.
ever run into anything there, or what, maybe some interesting preferences that your clients have had?
Yeah, I think talking about this more so is important than what's written in the will. So it's almost outside of the will, but there will be things like burial expenses are deducted from the estate and that sort of language within there. But more importantly, just writing down for your family members what, like, do you want to be cremated? Do you want a funeral? Do you want to be buried somewhere? Do you want the latest one I saw that I wasn't sure about, and I forget the name of it, but essentially you're putting water and you're dissolved that way, like chemically, sort of
Or
like
turned
more of a
into a tree.
green.
That's a big one.
Yeah, like recomposting. That's a more popular one, particularly where I'm from, Washington State. They have a few places that do that now. And one of the first in the country. So there's just different methods that, what do you want to have happen with your body? And then do you want services relaying that? And while we're on it, you do need the original for the will. I think that catches people off guard. Even when my dad passed away, that was one thing that I didn't quite realize or didn't think of in the moment. And we had a hard time for a little while tracking down the original of the will. We had plenty of copies digitally in paper and all that. But it did take some time that when you go to file that with the court, that I think a lot of people, if you've never done this, you actually do need the original signed copy of that. So it's really important to keep that in a safe place where people know where it is and can gain access to that.
Yeah, absolutely. Yeah, and I think, on a more positive note too, other than just, death and burial and all of that, like this can be your opportunity to outline like, hey, I want a celebration of life. I want it here. I want 3 kegs of local beer and I want people to have a good time. Like that's kind of your opportunity to lay out what it is you want to have happen. And again, the whole theme of this miniseries here is this really is just directions for you to give when you can't give the directions, right?
Yeah. And if you don't want services, that's also a great place to put it, right on the other side of that. And I think that's important to keep in mind because I talk to more people nowadays who are like, hey, I'm dead. It's not really for me. If my family member wants to do it and that would bring them peace and enjoyment, great, they can do that. But otherwise, don't necessarily need it.
I have seen in some clients' documents, I want to be efficiently disposed of. And that's totally valid if that's what you want. So
Yeah.
I don't know. Sometimes I get a good chuckle out of things like that, but it's
Yeah.
so spot on for the person. So
Definitely. I want to go back just for a moment, Matt, about like specific items. I think that's really important that the attorney usually will provide a document in the back where you can specify, I want my diamond ring going to this, or I want my lawnmower to this. Like you can specify all that. That's really important to do. Or if you don't, have a family conversation. I've also seen sometimes where people will put like a yellow sticky note, like everybody gets assigned a different color, yellow, green, whatever, and put it on the back of items. Now I know that sounds pretty morbid, but if you're in your 80s and 90s and not in good health, but you can have conversations with your family members of like, hey, why do you want that? Like that might be a really fun conversation to have of that painting. I always enjoyed that growing up, just as an example. And I'd love to see that in my house here. And so enjoys that as well. So I think that can be, more so than like the requirements and some of the icky feelings around death. Like there can be some joy within this process.
yeah, it can be a good time to, look back on memories. And I think too, like, sometimes there will be awkward conversations. Like you can't 100% eliminate those. However, I will say that usually if these conversations are had in advance, and if you have multiple children and 2 of them want the same thing, I usually there's some form of a compromise that can be made that's not going to tear the family apart. But just know that if you don't have those conversations in advance, right, that is kind of a risk you're taking of having who knows what decade-long arguments could arise from that. So sorry, can you hear the jet?
I
It's
can hear that.
yeah, it's very loud. So my apologies.
um, should we go to trust next?
Yeah, let's hop on over to trust. I'm gonna let you take it, and then that way I can cut as much of the jet out as I can.
Sounds good. So when it comes to trust, oftentimes you're not just doing a trust alone. People in states where trust makes sense or situations where it makes sense, they're also going to have a will. And oftentimes that's called a pour over will. So all a trust is it becomes the owner of these documents. So there's lots of different trusts out there. I'm specifically talking about revocable trusts where someone decides either as a married couple or an individual, they're going to grant the money into this trust or the property. They're also the beneficiary of this trust, and they are the trustee as well. So they're taking on those three different roles. So essentially, they get full use of this property as if they owned it themselves, but the trust is actually going to own it. And you can name your trust pretty much anything that you want. That's the fun thing. It doesn't have to be the Matt Fizell Family Living Trust. It could be the, I don't know, Green Leaf Tree Trust, as an example. I'm just looking outside at some green leaves, but lots of different options there. But the main thing here is the trust is owning it, so you don't have a bunch of assets going through probate. And probate is the thing that happens when you die if you have assets in your name. So you die, the court oversees that and wants to make sure, does the executor actually follow all the instructions in there, and do assets get to the right place? Are all debts paid off? Are all taxes paid? Does everything go smoothly as they expect? The trust essentially negates that. So because the trust owns it, you're not going through probate. If you die and you're the trustee, usually, hopefully, there's a successor trustee that can take over and then distribute assets in whatever way that the trust says to do it. And that might be new trusts, that might be outright to someone, that might be outright to a charitable organization, lots of different things. So the trust becomes the owner, that all happens, and then essentially similar things are written in the trust as the will of what happens to those things when you die or what happens throughout life. Matt, what would you add?
Yeah, I mean, you mentioned the court, right? They want to make sure that the right things are happening, but they also want to make sure they get their cut of the estate, right? So anything that goes through probate, usually there's, some percentage or some fee assigned to it as to what it's going to cost for that asset to go through probate. So again, not a big deal if it's $1,000 bank account, but if it's a $400, $500, $600,000 house, that can add up pretty quick. So I don't know if you hit too much on that. Sorry, the jet was
No,
a,
I
a tad
did,
bit distracting.
but I think that's worth talking about more so of like what states like attorney fees, are they based on the probate amount or are they just a flat fee? So I always go back to this idea in Washington State, for example, probate tends to be fairly easy. So most people don't have trusts unless there's another situation for that. Whereas 2 states down in California, there is a percentage base that attorneys can charge. And so a lot of people end up with trust because if you have $1 million, you might be paying tens of thousands of dollars or more to settle that estate. Whereas in Washington, maybe to settle that, you're paying $5,000, just as an example.
Not to mention, it can take some time.
Can.
Like in that, I have a situation with a pro bono client of mine where it took like a year for them to be able to sell the car of the deceased spouse because it wasn't properly titled, and it was just like this whole thing. And so not only was there a lot of change going on, but they couldn't even sell the car that had a loan on it because it wasn't in their name, and that's money they would have loved to have in that situation. So it can take a lot of time, and I think it's been worse since 2020, like when the courts shut down for a while. Like I don't know if some states are getting through that backlog, but I feel like it just put this really big like stress on the system, and it's never really been quite as quick. So yeah, definitely want to avoid that where you can. I also want to hit, Elliott, you said a couple of terms there, right? Trustee, like, grantor is probably going to be one that shows up in those documents as well. But, grantor, that's really just a fancy way of saying who gave the asset to the trust, right? So if I set up my trust, sorry, the jet's coming back. If I set up the trust and I put in my house into the trust, I'm the grantor of the trust, and I granted the house to the trust. And then while I'm alive, right, like Elliott said, if I'm the trustee, I'm the one managing it. So therefore, I would be able to, in a revocable trust situation anyways, I'm the one who's going to take the house out. But if, in that case, Elliott were the trustee, he would say, no, Matt, like I decide whether or not the house can leave the trust. Right. Is that a simple enough explanation for that?
Yeah, simple enough.
Yeah. And then two, thinking same with the will, like in terms of the executors, like having those successor trustees, right? Especially maybe you have multiple children, like, again, I think Elliott it was a joke, but I think it's a fair way to think about it. Like in this case, you probably want the more responsible child to be the trustee. And I'll never forget, I got a prospect call from Google like 3 or 4 weeks ago, and he's like, yeah, like how much can I take out of this trust? Like the trust company's telling me I can only take this much out. I'm like, well, what do you want to spend it on? Like, are you going back to college? He's like, no, like I really want to go on a vacation to Vegas. And I'm like, dude, this is exactly why they have a trust in place for you, right? So that trustee is there to help understand and make that decision on, is this money coming from the trust to whoever the beneficiary of it is it a reasonable or allowable even distribution from that trust to help accommodate whoever it is you're giving your money to. So that probably would not have been a accommodated expense.
Yeah, and that's the nice thing about trust is you can write them really any which way in terms of support for yourself or for others if sub-trusts are created at death. I think the key to remember with trust is if you go through all this careful planning and you create the trust through the legal document, the attorney is probably going to suggest actually funding the trust. And there becomes sort of the administrative piece of this is if you had 8 bank accounts in your name, now those 8 bank accounts may need to be titled in the name of the trust, which means if there's 8 bank accounts at 8 different financial institutions, you're filling out 8 different sets of paperwork. A big suggestion for maybe why you might want to consolidate and simplify. But brokerage assets, essentially like houses, any non-retirement accounts, you're going to want to actually fund the trust, because if you don't, then you may still end up with probate with that will.
Yeah. And two, like, especially if you have minor children, making sure that when you get this set up, like making sure that you're taking your attorney's recommendations on how your retirement accounts should be, set up with beneficiaries on the back end. Because, a kid inheriting a $500,000 401k, if they're not 18, that's an interesting situation there. Same with houses, right? Like if you have minor children, like I think there's a really strong argument to be made for having a trust, especially if they're like 1 and 2, right? Like there's just a lot that could happen in the next decade and a half. But yeah, definitely talk to your attorney about that. But like you said, it could be a lot of paperwork. You may have to go to the courthouse to retitle your house to the trust. That could then trigger that you need to add your insurance policies with the trust name on it and all sorts of fun things that come down the pipe. But we're not trying to scare you away from this. Like if you do this right the first time, the odds of you needing to make substantial changes like this again are very, very low, at least for the foreseeable future. Right, Elliott?
Yeah, usually things are in good order until like a law change or something significant in your life changes, in which case you can write an amendment to the trust to change a specific section.
Yep. And with that, it's not like you have to pay the whole $5,000 again. So
yeah,
if you do it right the first time, then it should be a lot easier, as most things are, right? If you do it right the first time, it's a lot easier to make changes as you need to.
Yeah. One common thing I see that I want to pay a minute to, and Matt, I'll be curious to hear your perspective. Sometimes I see people like, let's say they have 2 children. They're the trustee of their own trust, but then they name their children as co-trustees if they're unable to be the trustee of their own trust. I will say generally, and this is not legal advice, generally, I do not like to see co-trustees. I think it makes it really challenging if there's a disagreement, but then also just administratively, needing to sign every piece of paperwork becomes more of a challenge. So I often like when people pick one specific person, and this may be a tough conversation if you have kids and you're picking one kid over the other for that role. That can be a hard conversation to have. But I've just seen so many situations where you name 2 people, then there's a disagreement, or just getting things done becomes a very challenge in our everyday busy lives.
Yeah, I would echo that. Unless I feel like one's okay, not 2, but maybe 3. Like because usually you can find a majority somewhere, right?
Sure.
Like, but yeah, 2, not a big fan of that. I think we'll talk about this more in the healthcare the power of attorney episode, but I think there's a different answer to that question for me personally on that front. but for a completely different reason. So stay tuned for that
Interesting.
episode.
I'll be curious about that.
But yeah, I would agree with that, unless there's like some outline of like, this person's the main trustee, but this person, they have the ability to make a decision. I don't
Act
know.
independently, right?
Yeah,
Sometimes you'll see two people named and one can act independently.
yeah, and usually you see that when it's more like, okay, like this half of the trust is this person's, that half of the trust is that
Sure.
person's. But now I think we're kind of getting into the weeds on
Yeah. I don't think
how
we have
these
to go
things are
there.
structured. But yeah, but I think that's a really good thing to bring up too, because I have seen it where, upon death of the first spouse, then it's spouse plus a child as like co-trustees. And I'm like, I'll never forget the guy's name. It was Bob. Like, I'm like, you sure, Bob? Like, he's like, oh no, I don't. Why would I do that? Like, and he just didn't know because the
Yeah.
attorney, for whatever reason, drafted it that way. And it was like, that would have been a
Yikes.
nightmare for his wife. And I don't think she would have been too happy about that
Yeah.
either. So,
Should we wrap up with maybe a brief explanation of when we see trust make sense versus a will-based plan?
yeah, let's do it.
Okay, so the big things I see, I've talked about this previously, but probate's expensive in your state. So you'd have to figure out, hey, is probate an easy process in my state? Is it not very costly? In which case, maybe a will is okay. Second reason I often see is people have assets in multiple states. So we're trying to avoid probate in multiple states. So if you live in Wisconsin, but you have property in California or in New York or somewhere else, right, as an example, and you like, let's say you have property in 5 states, you may be having probate in multiple states, which you can imagine trying to hire an attorney in each of those different states, how challenging and complex that would be, as well as costly. So that's where sometimes a trust can be helpful, where you put the assets in that. And again, you're sort of avoiding probate if you get everything into the trust. The last one I would say, and Matt, maybe you have a different perspective or there's no one I'm forgetting, but privacy. So as I talked about with the will, you have to go file the original with the court. That is actually public knowledge. People can go look at that. So, whether you have $5 or you have $50 million, if you want privacy within that, the trust doesn't go through probate. So people don't necessarily know what assets got split, what homes went to who. You could deduce fairly accurately how much money an heir or a beneficiary is going to get if you have just a will, whereas a trust, you're not going to run into that same issue.
Yeah.
So those are the big 3 that I usually see for
Yeah.
trusts.
I'm going to echo those, but I'm also going to add 2. So
Okay.
the first one, I've already said it, but if you have minor children, like it's just one of those things where, again, I mean, Allison and I are at the stage of like talking about kids, and it's like, I would not necessarily trust whoever's going to take care of our kids. You see what word I use there? Trust, right? To make some of the decisions as to how we want the money to be used, right? So I think like having those guiding principles and having something there for them to follow for at least, I don't know, the first 25, 30 years of their life, right? And then secondly, we should have talked about this more, but special needs children, right? If you have a child with special needs to any degree, like having some type of trust to either help protect their benefits, to make sure that they're going to have the special care that they need taken care of and paid for, like those are super, super important reasons that you should have a trust, or at least have a discussion about having a trust with an attorney. So
I might just add, Matt, or
yeah.
putting specific language in your will that creates trust on your death. You don't necessarily need the trust throughout life. You could specify that within your will.
I guess I view those as one and the same, but you're
Sure.
absolutely right. So
I just want to specify for people listening, like if you're like, hey, I have a special needs child, or I have kids and I don't have a trust, it doesn't necessarily mean you need to go out and get a trust immediately, but do check your will. Like, does it specify what happens, and does it account for those different things?
Yeah.
It's complicated, but like
yeah. But yeah, I think those are the big ones. And I think for anyone listening, like if any of those things apply to you, or you're like, I don't have these, or I still don't know what the heck this is, like feel free to reach out. We have a ton of great people that we can certainly refer you to and get you connected to. Or I'm sure we can probably find some. Elliott and I know planners all over the country. So if you're not in Wisconsin or Washington, since Elliott has that hybrid specialty there, reach out and we'll do our best to find someone for you.
Definitely.
All
And
right,
if you're
Elliott.
thoroughly confused at this point, hopefully you're not, but drop a question down below and maybe that'll be a future episode.
Yeah. We just took 30 minutes away from their life. So,
hopefully you learned something.
Go get those documents done too.
Yeah, definitely.
All right, Elliott. Good conversation today. See you next time.